Great to be here. Thank you for reading the paper. We do think it's a very important and timely topic that needs to be seriously addressed. One line in the paper relates to a story that happened to me when I was a criminal prosecutor in Chicago, trying a murder case, first chairing the murder case, and the defense attorney, on cross-examination of my investigating homicide detective, started asking questions that began with the form of, during the course of your investigation, did you have occasion to learn? Now, anybody who's tried a case knows the answer that's going to follow that is hearsay, which is objectionable. You would object before you even find out what the rest of the question is. However, I did not object, and I did not object to a series of hearsay questions that followed up. Once I didn't object to the first, I didn't object to the others. While this was happening, my partner, who was junior to me, second chairing, was shifting in his chair, thinking that his first chair had gone mad. The judge, who I'd known for now several years, very cantankerous old Irish judge, was glaring at me. If he had had a gavel, which he didn't have because he said if he had a gavel, he would just throw it at lawyers. He just was glaring at me, waiting for me to make this objection. But luckily for me, he had enough confidence in me to not make the objection for me, to not interpose the objection, figuring I must know what I'm doing. And I did know what I was doing. And maybe after this, I'll explain to you what I was doing, why I wanted that evidence in. And I couldn't introduce it myself. And now the defense is introducing it for me. Thanks, that's great. In fact, the defense attorney at the next break told his client, well, George, they're letting us have our defense. They must not think it hurts them very much, which was exactly true. Now, this is an example, I think, of how the adversary system relies on a kind of party presentation idea, and that is that we knew our case, I knew our case, the judge didn't know our case. The hardest thing about being a trial judge is the fact that you think you can try the cases better. You're up there thinking you can try the case better than the advocate, but chances are you can't because you don't know what the advocate knows because you're not supposed to know that stuff. And so that's sort of the origin of the intuition on behalf of the party presentation principle. It's a common law doctrine. It's a doctrine that involves the adversary system. I think it makes a tremendous amount of sense, both at the trial stage, when lawyers are entitled to structure their cases the way they wish, and at any sort of dispute resolution stage, even on appeal. As long as we're dealing with dispute resolution, then it makes sense to rely on the parties to make the best case for their client that they can and live with the results. However, we have a written constitution that's superimposed over whatever common law system we have, whatever adversary system we have, and judges and other constitutional actors owe a duty to adhere to the meaning of that constitution where it's clear enough to guide them. And in that case, there's actually, it is not merely dispute resolution, especially when you get past the trial court and into the appellate court. What's going on in the appellate court is the making of legal rules in form of precedents, either intra-circuit precedents or at a higher level, precedents for the whole country that are going to bind a whole lot of people beyond the parties. It's like what we see today in the paper, something like a kind of a class action. And at that stage, it's not clear, for the reasons we explained in the paper, why judges should be constrained to only consider constitutional arguments that are raised by the parties, or at the very minimum, they should only be constrained to pursue the kinds of constitutional arguments that parties have presented, lawyers have presented. There's more to it than that. Before I turn it over to Larry to basically state our more affirmative thesis, I want to stress the fact that one of the things that I didn't realize when we went into this project that soon occurred to me, and that is the negative effect of the party presentation principle is especially acute because it's interacting with the doctrine of stare decisis. I hadn't really seen these two work together and how the damaging part of party presentation is a result of the outcome of a case being precedent that will guide other cases. And so stare decisis, which is another common law doctrine that makes perfect sense in an evolutionary common law system that's trying to develop rules that decide disputes among private parties and develop rules of law that eventually will result in the law of contracts, property, and torts. You need a doctrine of stare decisis for that purpose. It's not clear when it intersects with a written constitution, a higher law that's superimposed above all of this, that there's a very comfortable fit there. And then when these two common law doctrines, each of which makes sense in dispute resolution context come together underneath a written constitution, now you've got a real problem. You have painted yourself, the court is now painting itself into a corner that's going to allow Supreme Court bar to control the meaning of the Constitution and how it gets interpreted by the courts, and that can't be right. And in this paper, we try to explain why it's not right and what should be done about it.
We're almost out of our time, but I just want to emphasize that a lot of the work in the paper is being done by the discussion of possible rationales for the party presentation principle, and in particular by our argument that the epistemic justification for the principle does not make sense if you are an originalist judge and the parties have presented no originalist arguments. It is hard to see how we get a better originalist result out of that combination. Just one worry point in the paper that we, I think, continue to work out and would appreciate feedback on concerns exactly how stare decisis ought to work when the originalist arguments have not been presented, right? And now lower courts are deciding a case in which there is an originalist argument, and how then, how broad or narrow is the court's obligation to follow the non-originalist precedent. I'll just stop there.
I don't know when I was asked to comment if Mike realized that I'm not just a scholar of federal courts, but also a former appellate litigator. So I just want to say on behalf of all current and former appellate litigators, ouch to this paper. All right, so some really, really important and terrific stuff in the paper, and it really is an excellent contribution. It gets us thinking hard about where we have this party presentation principle, where it comes from. Does it come from something in Article 3? Does it come from just general practice? Is it a matter of common law, general common law? I think this paper gets us thinking about those things. Steve Sachs tells me there's a student note talking about the party presentation principle. I think there needs to be more scholarship in this area as to the source. And I think this paper is important for that reason, whether or not you agree with it, and even whether or not you're an originalist. And that's a terrific contribution. Okay, so concerns. So one of the things that struck me in reading your paper is if we're getting rid of the party presentation principle or significantly limiting it, that's not going to just be in the context of originalism, but should be in every context, because the party presentation principle restricts the development of law, not just in this area, but in every area. And there are a couple of big concerns about that. You talk about originalism as being very important on grounds of stability and predictability and consistency. But if we ditch the party presentation principle, not just in this area, but in any area, or even if it's just in this area, we're losing a lot of that. So on the retail level, in litigation, one of the things that makes litigation work is that people come into the litigation with a common understanding and a consensus that the parties will frame the case, not just at the trial level, but also at the appellate level and at the Supreme Court level. If we lose that, litigation becomes a free-for-all. I have had cases where I thought, boy, the other side did not make the best legal arguments. I could write a better brief for the other side. I had a question at oral argument where a judge said, counsel, isn't this why the statute is constitutionally vague, unconstitutionally vague? And I thought to myself, no, actually, Your Honor, that's why it's unconstitutionally overbroad. But I can't say that because that's not good for my client, the federal government. So there are lots of situations like that, and the retail level would become extremely complicated. But I think even more problematic, the wholesale level would become extremely complicated. The very reason that you object to the party presentation principle is that it makes the law develop more slowly. But that's precisely why the party presentation principle helps preserve stability and predictability in our system. If we jettison it, we're going to hurt a lot of the values that you purport to favor. I also think it's a bit inconsistent with your argument, your own acknowledgement, that if originalism becomes ascendant, it will do so very slowly. This would make it go really, really quickly, depending on the judges. So on the legal source of the party presentation principle, and this is why I think your paper is so important and so valuable, I might have thought it does come from the Article 3 judicial power or the case or controversy requirement, or at least it's connected to those things. And one of the things I just wanted to flag for you, Leo Brillmeyer's work on standing doctrine actually mentions one of the values that you underscore, party autonomy and fairness, as some of the values undergirding standing doctrine. And so if you're right, does that undercut at least that argument for standing doctrine? Probably just a more friendly comment. I also got to thinking about whether adversariness is a requirement of Article 3. So in United States versus Windsor, Justice Scalia said, yes, it is. Kennedy said, no, it's not. Henry Monahan and I have both argued, no, it's not. So that could be helpful to you just in terms of thinking about the extent to which this is tied to or not tied to Article 3. Okay. So next set of comments, and by the way, I've written all these down and I will send these to you so you don't have to take notes. So I was struck by your argument, your connection between the party presentation principle and stare decisis. You say, quote, for better or worse, stare decisis converts constitutional challenges on appeal into something like class action lawsuits, end quote. To my mind, that was a pretty stunning claim and would have massive implications for procedure. It would suggest that everyone should be able to intervene as of right in pretty much every case, because by golly, we're all parties to this class, and might even mean that every single person has standing on appeal to challenge a judgment, at least on a constitutional matter that they disagree with. And that would be a huge change in the law, and also just a huge change in understandings of both intervention and standing doctrine. Next, vertical stare decisis. I have strong views on this topic, have written about it. Kurt Bradley and I have a paper right now on this topic. I agree with you that vertical stare decisis is required by Article 3. I think that is required by an original understanding of Article 3. I think it's required by a current understanding of the text of Article 3. But if that's true, it struck me as very surprising that you think lower court judges could disregard even what they view as demonstrably erroneous Supreme Court precedents. If we have an original understanding requirement of vertical stare decisis, it's hard for me to see how that's just defeasible by a different original understanding in the particular case. It also was surprising to me that if lower court judges can disregard Supreme Court decisions that they view as demonstrably erroneous on originalist grounds, why would that be limited to cases where the parties failed to make originalist arguments? Because one of the things I took from your paper is that parties sometimes do a really bad job at making originalist arguments, and so why would it be limited just to that context? So it made me wonder, could you potentially limit this argument to the United States Supreme Court, where I think it could actually work a little bit better. Your paper made me think of a piece by Ryan Williams, which I don't think you cite, on lower courts dealing with originalist arguments. And I don't think Ryan's here, but one of the points that Ryan Williams makes in that paper is that lower court judges, because of their more limited resources, their much larger caseloads, and the lack of amicus curiae briefs and things like that in the lower courts, just don't have the same institutional capacity to do originalism that the U.S. Supreme Court does. So one possibility is to limit your argument to the U.S. Supreme Court. Just a couple of small points, and then I'll have a final kind of practical concern at the end. You say that you're not really going to deal with issues of preservation below. I think you kind of have to. So I take your argument to be focused primarily on the courts of appeals and the Supreme Court right now, and you seem to think party presentation at the trial court level is a little bit more defensible. But if that's true, appellate lawyers have a big problem with issue preservation. If the trial court lawyers are not making the arguments, the trial court judges are not making the arguments, and the appellate court judges then have to raise them. So I would address that. Another small point, one of the things that occurred to me in your paper, and you get to this on page 32, is that you could potentially solve some of the problems by just having the appellate court ask the parties to brief originalism. But it's not clear to me that that really solves your concerns, because one of the things you say in the paper is that attorneys don't learn this stuff in law school. They don't really know what they're doing, and so they might do a bad job. I will also say, when I was at DOJ, one of the things one of my fellow appellate litigators said to me before an oral argument was, okay, if they ask you about that, just offer a supplemental brief. Every judge will turn down the opportunity to get a supplemental brief because they never want to do more reading. I don't know if that's still true, but it seemed to be true at the time. Okay, so my final concerns, and I do want to underscore, this is a terrific paper, right? It's just triggering for some of us lawyers. It's a wonderful scholarly project, but I wonder about kind of the practical impetus and the practical implications. What I take to be the impetus of this paper is a concern that right now a lot of really prominent appellate lawyers didn't have training in originalism, are nervous about making originalist arguments, because it is true that when you're trying to win a case for your client, you're trying to win a case on whatever ground you can. But I think that's changing. Right now, we have a lot of originalists on the U.S. Supreme Court. We have more and more originalists on the lower federal courts. If you are a government attorney or a private attorney, you know you're going to have to include originalist arguments. I view it as kind of the transition from a purposivist world into a textualist world. When I was in law school, which was a long time ago now, David Shapiro said to us that when he was at the Solicitor General's office, people started with legislative history. And by the turn of the century, they were starting with the text. This was not because textualism was taught in law school. I didn't have a course on statutory interpretation when I was in law school. There wasn't a course on statutory interpretation when I was in law school. John Manning did not join the Harvard faculty until after I graduated. And yet, people were getting the message, start with the text, because of Justice Scalia on the US Supreme Court. I think people are getting the message. You've got to include the originalist arguments, which allows the judge to use them. The second thing, if originalism does become ascendant, as I know the people in this room want, many members of the US Supreme Court want, a number of members of the lower federal judiciary would like, if it does become ascendant, the party presentation principle will protect originalism in the long run, precisely because it makes legal change slower and more difficult. So I do wonder if your paper might have the unintended consequence of making it easier to get away from originalism going forward. And I will stop there.
Thank you so much, Tara. Those were just wonderful comments. Owen Smitherman, who is the student you're referring to, I'm sure would thank you for the call out. His piece, which is just terrific, is up for a board vote at the University of Chicago Law Review on Tuesday. So it's not a student note, actually. So one point that Tara makes, I just think is very important. It's not discussed in the paper the way it should be. And that has to do with the relationship between the party presentation principle and the rate of legal change. So I think Tara is right. You could make an argument for the party presentation principle on the ground that it is sort of a phase-in mechanism, right? And that party presentation plus the time it takes to change the legal profession, to change appellate advocacy, work together to sort of ensure a long-term phase-in for originalism as opposed to a short-term phase-in. I think that there is something to that argument and that we ought to address it directly in the paper. I do think that that kind of argument isn't up to the task from an originalist perspective of justifying what I think is likely decades of infidelity to the Constitution, to the original public meaning of the Constitution. But that's something we don't say in the paper, and we need to say. I want to clear up what I think is a misimpression. So it is true that we say there is a way in which the doctrine of stare decisis turns constitutional appeals into class actions. But we don't mean that all of the legal consequences of class action should follow. And if you got the impression that we were making that move, then we definitely need a footnote that makes it absolutely, totally clear that that is not our view. You raise an important question about vertical stare decisis and defeasibility. And so I think that, again, we need to clarify. So we are not saying that the doctrine of stare decisis should not apply to originalism. Instead, our strategy is to articulate a theory of stare decisis, the ratio decidendi theory, that identifies the holding of a case with the legal norm that is implied by the reasoning necessary to reach the outcome, given the legally salient factual characteristics of the case and the issues put in play by either the parties or the judges before the decision is made. So given that theory of stare decisis, which I've written about elsewhere, and which I have a treatise on stare decisis, so this is something I care very much about. Given that theory of stare decisis, we are not arguing for an evasion of stare decisis. We are arguing that the proper understanding of stare decisis allows consideration of issues that were actually not decided by the appellate court. You and John Harrison both have suggested that we need to talk more about preservation, and we will do that. We will do that. I do think that if you understand the way preservation works in relationship to our typology of the scope of the party presentation principle, it turns out that what is being preserved are claims and then issues via motions. And that form of party presentation we're down with, right? We do not object to the idea that if you below don't raise a constitutional claim at all, we're not saying that form of the party presentation principle is inconsistent with originalism. We think that form is fine. And the same thing would be true of motions. So, for example, if you don't make a 12b2 motion objecting to personal jurisdiction, you now have lost that objection and you have not preserved it for appeal. We are not saying that personal jurisdiction should become raisable, I guess is the word, sua sponte, on appeal. We don't actually deal in this paper with the categories of things that can be raised sua sponte, and maybe we do need to do that. But to the extent that you read us as suggesting, well, to the extent that our lack of consideration of preservation might give rise to the misleading impression that we're saying that claims and motions can be made for the first time on appeal. We absolutely must clarify that. I don't think I'm going to respond to anything else, but that was very rich, and there's lots of changes we'll be making.
Characteristically great paper, of course. I will say that when I read the title, I thought I was going to be reading a paper about the original meaning of Article 3 of the Constitution and whether or not the party presentation principle is dictated by, consistent with that. And I wasn't. There's a few sentences about that basically say no one has ever seriously made this argument. But that doesn't surprise me because, as you say, no one's ever seriously thought about this before. So I'm just surprised. I feel like I'm not sure that there wouldn't be a reasonably compelling argument out there that the party presentation principle, at least in some form, is baked into Article 3 in its original meaning, or is an original method, or is a constitutional common law backdrop against which the Constitution must or should be interpreted. You know, again, tying up with some of Tara's points about how standing and other things have been, these are related questions that have originalist implications. And sort of in the absence of any of that discussion, what we end up with is a paper that's mostly about the party presentation principle gets in the way of the originalist project to radically remake the law according to original meaning. And to that extent, what can we do to mitigate that concern? And that, I worry, reads to maybe to a more skeptical audience as more of a political argument than a constitutional, legal, interpretive argument. And so I guess I would say, I would suggest that you expand that point and sort of defend the proposition that in greater detail that no one's made this argument because this is not a viable argument. Here's the original work that tells us why it's not a viable argument, and therefore that it's inconsistent with originalism. What do we do about that? I think you're kind of missing what I was expecting to be a big heart of the paper.
So my first question was maybe a little bit similar to that, just wondering kind of what specifically about the Constitution stops judges from applying the party presentation principle, and if it is just there are constitutional claims that don't get decided on originalist grounds, kind of what other arguments are there? And you raised preservation at the end, and I'm still processing exactly what you said about that and why we draw the line somewhere, but I'm not sure why that would be the case either. If a dispute involves a constitutional question, but just because the parties don't happen to raise that specific claim, isn't that also inconsistent in the same way you're saying that the party presentation principle on more specific levels are inconsistent? And then maybe one point on, you address the theoretical justifications and rebuff them before you talk about the scope of the party presentation principle. And it seemed like sometimes when you were rebuffing the justifications, you were able to say, well, this wouldn't apply if it's really broad, and then elsewhere this shouldn't apply if it's really narrow. But it would be helpful to me, and then, you know, to say exactly, you know, a broad party presentation principle might be justified in these ways. And it seems like, Larry, your comments at the end were saying that maybe you actually do agree with some party presentation principle, but addressing the theoretical justifications without it precisely identifying what the actual principle you're arguing against was, left me confused about exactly your position.
My friendly amendment to Tom and Tyler's question might be just, why isn't Owen Smitherman right? But my question is about precedent. So suppose I think that the founding era account of vertical stare decisis is different from our account today, and that it didn't depend on the ratio descendi, as indeed it couldn't in a world of seriatim opinions where there was no opinion of the court, and indeed opinions were frequently unreported and unknown. And instead, I think the originalist conception of vertical stare decisis looked only to the result, or perhaps required lower courts not to do things they were sure would get reversed. If that were our conception of vertical stare decisis, would the paper change a lot? Because then we wouldn't need to sort of mess around with the party presentation principle to solve problems with stare decisis.
Thank you, Will. For those of you who haven't read Owen Smitherman's paper, it provides a defense of the legal grounding of the party presentation principle based on original law, originalism, and an account of the general law. So, we didn't say anything about it because Smitherman gave us a copy of the paper that said, do not discuss or cite or quote. So we couldn't do anything with that argument. He now has given us permission to discuss his paper and our paper. So we will be discussing the general law theory. The second part of this, what is the original version of stare decisis? This raises a lot of questions. I just want to say it looks very differently if you're an original law originalist who would believe that the original law of stare decisis remains valid unless it's lawfully changed, and then there's a lot of work to do to figure out both what the original law was and whether or not any lawful changes have occurred. But our paper just does operate within the framework of public meaning originalism, and we do not believe that the original meaning of the constitutional text includes a version of stare decisis, and as I understand it, that is limited to outcomes. Is that what you said? So but we'll think more about that question.
Yeah, I'll take briefly respond to Tom's argument. I don't see exactly why, couched the way it is, it's a political argument. I do take your point, and I didn't actually think about it until you made it, and that is that the title suggests it's going to be an originalist analysis of the doctrine rather than an analysis of the impact of the doctrine on adopting original meaning, which is what it is. I still think the title is apt, but it is ambiguous. But I think the meaning becomes clear as you get into it. I don't think the latter, what the actual substance of the argument is a political one. If you take as given, which Larry explains why we didn't take into account the general law background idea, but if you take as given that this is a judge-made doctrine, then it's subject to judicial modification. It's actually, as we show, relatively recent in terms of it being asserted with any force and completely under-theorized. And the fact that it would impact the ability of courts to adhere to the original meaning of the Constitution is a serious objection if you are an originalist, and it's not a political one. It would be applied to whatever the original meaning stipulates from a political outcome standpoint. So I do think the title point is well made, but I don't think it's a political argument.
And I just want to take on board the comments about needing to clarify why claims are different and that there is a structural issue about discussing rationales before scope. Those are both good comments, and we will think seriously about them.
I also, in the spirit of other previous presenters, we tried really, really hard to keep to the 25,000 word cap for purposes of law review submission, which meant we could not talk about everything. There are sections of the paper that aren't there anymore because they wouldn't have made the cut, and now we don't know what Penn will allow us to add in terms of length, but we're hoping now that we're in the door that we can add some sections that we think should be there.
To be frank, did not particularly care for the paper. My objection really is just about which questions are legal questions and which ones are more sort of normative questions, even if they're about law. So what I'm trying to figure out is to what extent are you concerned about how people would have thought about legal rules of party presentation at the founding and how we might think about legal rules of party presentation today? So, I mean, I shared Tom's intuition that sort of based on the title, we were going to read about sort of examples of how this had been handled at the founding. There's some in Owen's piece, there's some in my piece on Dobbs and the Originalists. But if it seems like that would be informative of a question of like, well, what kinds of rules was the Constitution laying down? When we see the First Amendment, is that a substantive rule that then has to get employed through all of the procedural devices that might be based on sub-constitutional law that are sort of employed in the courts? So if a defendant doesn't make their First Amendment defense, then they lose it and they can't make it on appeal, and so all of these other consequences would apply. And it was very surprising to me that the discussion seems to take Erie from 1938 as like a good summary of sort of where we are, when you would think that originalists would come at it from a very, very different angle. And like the footnote 40 sort of realist approach is like not the way that folks at the founding would have been thinking about these things. So why is it that that's the proper approach to think about the party presentation principle from the standpoint of originalism? On the flip side of like, how should we think of this today? It seemed to me that this was sort of an engine for destruction of all procedural common law and indeed all procedural law generally. Because anytime you have a situation where some rule of procedure says you can't make your winning originalist argument, you're going to have a situation where the court will enter a ruling saying that. Now, maybe what you should actually be calling for the courts to do is to be more explicit about this, like reserve more questions. They did not argue X, so we are leaving argument X alone for the next case or something like that, so that it doesn't have the stare decisis effect where people think the court has rejected a position that in fact was never presented to them. But it seems like there are going to be a lot of procedural situations where somebody loses their good argument because of some procedural problem, like they filed their brief late, or they, it's a preclusion issue. They brought the case yesterday and lost, and now they just thought of these excellent originalist arguments and try and bring it again. The court says no. There are going to be lots and lots of situations. And if the theory is the Constitution trumps common law, well, the Constitution also trumps statutes. So it seemed like even statutory procedural rules would have to fall under this regime. Likewise, statutes trump common law. So if I've got a good statutory argument, but I forgot to make it, does this account of the party presentation principle mean that party presentation shouldn't apply even to statutory claims, regardless of originalism in the Constitution? So in sum, it seemed to me that the argument of the paper was, the party presentation principle is unclear and messed up, and I think everybody who talks about it would agree with that. The courts right now are not sure what's an issue and what's an argument and all that kind of thing. But it's ultimately suggesting a sort of normatively attractive way of doing party presentation. But that seems to me very different from a claim that this way of doing party presentation is in fact legally acceptable today under the correct law, even as sort of an originalist would determine it. That seems like a very different argument and not one that the paper makes, but one that seems to be part of its burden.
My comment is sort of a version of Will's, but I think mine is more, I'm not sure how Will meant his. Sounded like you took it as a criticism. And mine is much more sort of a friendly amendment. So I see this paper as part of the conflict between the case-deciding function of courts and the law announcing function of courts. And that's changed over time, at least at the Supreme Court level. If you go back, my understanding of precedent at the time of the early years is, it was a series of decisions that would establish something. David Curry, I think, even Curry nods. He's like, well, Marshall doesn't cite the earlier case. He decides it again. Well, yeah, because one case doesn't necessarily establish a principle. Well, if you have that kind of system set up, it's much more of a sort of case-deciding aspect to things, and the party presentation principle is going to be much less of a problem, right? Because the first case gets argued and decided a certain way, but they're going to hear another one, and then they're going to hear another one. So under the old system, it's not going to present the problem that you guys identify. So that's point one. Point two is if one's concerned, as some people are, about the common law and to what extent you're just sort of, getting rid of the old common law rules on just sort of normative grounds, you actually have an argument that can be made that says, look, circumstances have changed. The party presentation principle was originally, at least in this context, set up in such a way so as when you have to have a series of cases. It worked in a certain context. Well, it doesn't work that way any longer. The Supreme Court decides something and everyone thinks it's, lower courts, they don't merely follow the holdings of the Supreme Court, they follow the dicta. I mean, it's ridiculous. Given that, you can say, well, the common law needs to adjust to these changed circumstances, which is a much more traditional way for talking about the common law evolving.
With considerable trepidation, I think this paper misunderstands the party presentation principle, which, at least as I understand it, has nothing to do with additional arguments in favor of the same legal conclusion. That I thought Larry got it right in his last comments about preservation, that what parties must do is raise the proper objections, raise the issues, but then the appellate lawyers are free to offer whatever arguments they think are persuasive in support of the claims that have been properly preserved, and appellate judges are perfectly free. There's nothing improper about an appellate judge deciding the case on another argument that wasn't even raised by the parties. I think it's dangerous to do that. It shouldn't be done very often for prudential reasons, but there's nothing improper about it. And originalism is not a claim, it's an argument. It's a particular ground for reaching a conclusion, and thus I cannot think of how the party preservation principle, properly understood, stands in the way of making originalist arguments. I think lawyers are free to make whatever arguments in support of the properly preserved claims that are in the case.
The paper must not be doing a very good job of articulating what we think, because I agree with what you just said. Properly understood, the party presentation principle should not apply to arguments made in support of an issue that is properly before a court because the claim or defense was raised below and or the necessary motion was raised below. So I agree with that, but when you say we misunderstand the party presentation principle or the paper misunderstands it, what I would say is that the courts are very inconsistent, but that many court decisions do exactly what you say would be a misunderstanding of the party presentation principle. So, when the Supreme Court said that it was an abuse of discretion to consider a First Amendment overbreadth theory when the First Amendment claim had been raised by the parties, because party presentation applies not just to raising a constitutional claim based on a particular provision of the Constitution, you must present the precise theory of that provision. or when a court says, well, we can't consider an originalist argument relating to this constitutional claim because the parties only argued non-originalist arguments, then I think that the party presentation principle is not being applied as it should be. Steve, thank you. We disagree with so much, on so much at a fundamental level. So it does not surprise me that you find the paper unsatisfactory because it rejects your entire framework. And it applies a different framework, the framework of public meaning originalism, which we have articulated. So party presentation principle at the founding, what our work so far reveals is that it was very inchoate, right? And that it is today more coate, but clearly consists of inconsistent pronouncements. And at the founding, it appears to be both less coate and inconsistent. But we could do more on that, but we're not going to do it in this paper. We're probably not going to do it in this paper just for practical reasons. I think the engines for destruction point is wrong because I think that the work done by the typology of scope and the typology of effect, if applied to various procedural rules, would make it clear that what we are complaining about is not, to go back to the example of personal jurisdiction, is not that you lose a personal jurisdiction objection if you don't make a motion. It's that if you do put the constitutional issue squarely before the court, right, that is, you made the constitutional claim by way of claim or defense below, you preserved it on appeal, and then it is before the Supreme Court, then the Supreme Court ought to be able to consider the originalist position on the meaning of that constitutional provision, and also all the relevant evidence, not just the evidence presented by the parties. We certainly agree that the party presentation principle is messed up. And we think that this is an area of the law where the courts have the power and should exercise that power to revise the principle or to make the law clear and precise, where currently it's inchoate and where some of the judicial decisions utilizing the party presentation principle, but not all, because lots of judges do get it right, I think, that it would be proper for the courts to correct those mistakes because, and we for frankly normative reasons, because this is an area where the courts have appropriate lawmaking authority and where we believe both there is no precise, articulated, and consistent law, and where some of the decisions made we think are wrong, and the courts ought to use their authority to make the law better.
I could try to be quick with Mike because they were all kind of friendly amendments, so I don't have to push back against them. I do think the difference between case deciding functions and law announcing functions is an important one. It also goes back to Will's statement about seriatim opinions. The law announcing function, which is the view of stare decisis that says the holding of a case is what follows, we hold that, and now we have what essentially is a legislative holding by the court, cannot possibly have been the original practice, since you had seriatim opinions in which each justice is explaining why they did what they did. Common law judges, common law reporting rules were extremely scanty. Often you just got the facts of the case and the outcome of the case, and it was from a series of decisions that you could derive a rule, and that's the reason why it would produce an evolutionary process of rule generation and determination over time. Precisely for that reason, it's not the way the courts are operating now, and therefore, to the extent that that and a version of stare decisis was necessary to that system of dispute resolution, it wouldn't carry, it is a mistake to blindly carry it over into the present where the courts are not operating that way, just on the grounds that it once was a doctrine that had some purpose that made good sense. And so I thank you for those, the friendly amendments. I think they're correct.
Yeah, so just a couple of comments. My own experience as an appellate litigator was that party presentation principle was used in different ways. So is preserving issues. That's one of the reasons I think those are very much intertwined. As an appellate litigator, you're always trying to figure out, like, can we say that this is preserved? And it's very hard. And I think judges actually do feel in different ways bound by what the parties argue. I just want to make a quick comment about vertical stare decisis. I think Will and I have some disagreements on this. I think the original meaning of Article 3 is that lower courts have to abide by Supreme Court decisions. How that happened in the 19th century was different than how it happens today because not only of seriatim opinions, but the lack of publication of opinions. And the circuit writing, I think, was actually a really important messenger service for Supreme Court ideas to the lower courts. But more importantly, if you're going to take on vertical stare decisis and say there's not much of a lower court obligation to follow Supreme Court precedent, that could have massively bad implications for the ascendancy of originalism, because originalism is much more dominant on the U.S. Supreme Court than the lower federal courts. So just as a practical matter, I think it's a bad idea for originalists to say that lower courts are not bound to obey what the Supreme Court says.
We totally agree with that. Our view of vertical stare decisis is that it is baked into the Supreme Court clause, which is not a clause that names the title, that provides the title of the court, but it provides the function of the court relative to inferior courts. And the whole concept of an inferior court versus a Supreme Court is the inferior courts should follow what the Supreme Court says. Now, more work would need to be done to flesh out exactly all of that means, but we think this is baked into the Constitution. And so we totally agree with your vertical stare decisis point. But the issue is, what was the holding that is the stare decisis holding? And then we make the arguments we make. I won't repeat them.
One of the things that I usually admire about both of your work is your ability to see to the horizon. Like you in both of your work, I usually feel like you see the big picture and the and like the things coming after this and the limits of where it will go. And so I was really struck reading this piece that my dominant reaction was, you guys need to go much bigger. I think that, I mean, a couple of people have said, Tara says a version of this, and Steve says a version of this, and Mike Rappaport says a version of this. At root, what drives this paper is the tension between originalism as a theory of legal content and the established practices of the judiciary as we know it, right? In this one particular instantiation, the party presentation principle, right, which is a way the courts do things sloppily or otherwise. But I think, as a couple of people have suggested, if you solve that one, you're going to find another one and another one and another one, because the courts as we have them aren't built to deliver, to be like really good technologies or institutions for the kind of originalist law content settlement that you're seeking, right? The paper is awake to this, right? The paper explains, right? Courts have limited time, limited personnel, so even if the US Supreme Court may be better at it than some others, but even there, it's limited. I think ultimately, really where you would need to go, right, with the idea that's driving your paper is the judiciary has got to be replaced with some other decision-making institution, at least in cases where what's at issue, at least, is questions of original meaning as content of the law, because this institution is not well designed for that function. Now, as you know, you and I take different conclusions from that observation, right? I take it to mean that originalism might not be the best way to do law in a system where we have that institution as the decision maker. But you can flip it, right? You can say, no, like it's the case that there's a tension between the way this institution operates and the kinds of things that it's good and not good at given the constraints it works under, and the kind of law ascertainment that we need to do given the view that a certain kind of original meaning, originalism, correctly states the law of the Constitution. But then what you would want to do is redesign the institution not in a small beer way of saying get rid of the party presentation principle, but in a much bigger way by asking what would an institution look like that was actually really built to be good at that, right? So, for example, you talk about the resource of time, and I think, and the dangers of courts with the ability only to do research for limited periods of time and writing originalist opinions. And I think so maybe we should have a practice where courts, or at least the Supreme Court when it does originalism, should release a draft opinion to the public that's not their final opinion. And it should give all the people in this room and everybody else who's in the business 6 months to come up with sources that they missed and nuances that they missed and things about the sophisticated understandings of originalism that they missed and send them all the memos.
They tried that with Dobbs and it didn't
right.
go well.
And then
Jack took that from me.
And then they'll do it better. Or because when you think about like, what's the time lag between the court's decision of some opinion on originalist grounds and really good originalist scholarship that comes out a bunch of years later that eventually causes, informed audiences like the one in this room to say, ooh, they got that history wrong, and Judd is right, or Michael is right, or something. It's years, right? So maybe it's not a sufficient fix to do the sorts of things you're talking about. Maybe you need an institution that can set the agenda for what the decision, for what the issue is that needs to be settled, and then like commissions whoever it commissions, right, formally or informally, over the course of several years to hash these questions out and then decide them, right? So I'm just suggesting that I think that the real tension that you're pointing to is between your desire to get originalism right in a certain way and have that be the meaning of the law, and not just this or that practice of the judiciary, but really fundamental things about how the judiciary works and can't work well. And you could try the bricolage of making it work a little better here and a little there, or you could just like face I think in the end the necessary reality that what you really need to make it work is a different kind of decision-making institution and process.
Thank you. I found the paper, I had some concerns that were raised by the beginning of the paper, and then by the end of the paper, I was less concerned about it. And some of my concerns about the beginning of the paper, I think have been voiced by some others here. Tom began by saying, I was sort of expecting sort of more of an originalist idea of what the party presentation, what would an originalist say about the party presentation principle. And I can see why you don't talk about that much, but I think it's a really hard thing to avoid because at the end of the day, it's not that it becomes a political argument without that history. It's a policy argument that we should adopt this policy because we think it reaches the right results without regard to whether history mandates it or whether it's consistent with the original understanding of Article 3 and judicial power. Presumably, there's a variety of doctrines, some that we take for granted, some that we probably should question, but ripeness, mootness, stare decisis, party presentation, that are grounded in the original public understanding of the judicial power and should be maintained, even if in any particular case, they prevent the courts from reaching the right originalist result in, say, the First Amendment. because in a particular case, the judicial power just doesn't extend to the court's ability to hear that particular argument in that particular setting. And so I do think those are some of the concerns, but by the end I was a little less concerned because of the way you framed your ultimate, what I took to be the sort of the ultimate formulation of the best option for originalists. The party presentation principle generally should not foreclose consideration of originalist arguments, except in cases in which the court would be unable to reach reliable conclusions about original meaning without the aid of adversarial presentation of the arguments and evidence. And that sort of alleviated most of my concerns about the proposal, because the exception swallows the rule in the vast majority of cases. That the only cases where we would imagine that having adversarial argument would not benefit the judiciary would be cases where the text is crystal clear, or where the history is so unambiguous that there's really no controversy, in which case those aren't the cases that really get to the Supreme Court that much. You cite a second category where the scholarship would be pretty clear and uniform and not challenged, and point to Mike Rappaport's work on recess appointments. I'm sure even Mike would agree that, hey, having good adversarial argument about that and having people question that scholarship is probably a good idea and would lead to better results. So at the end, I kind of felt like your formulation sort of gives away the argument that you're making, that at the end of the day, that party presentation will always be there and is always justified, because almost every circumstance, maybe 95% we could say, adversarial argument would be advantageous to reaching more reliable results.
Thanks for the paper. I had two questions that both kind of orbit around the Judges' Bill of 1925, which turns 100 this week, and discretionary jurisdiction in the Supreme Court. So the first question is, it seems to me that Taft, others at the time, were quite explicit that their theory of the Judges' Bill was that the Supreme Court would be issuing something like legislative holdings. And I think that attitude, for better or worse, has kind of taken hold in our legal culture since then. And as evidence of this, I just wanted to raise and point to an interesting decision that came out just a few weeks ago by the Supreme Court. It was kind of a technical decision about supplemental jurisdiction. But there's a moment in the decision where the Supreme Court says, in this prior case, it was called Rockwell, we had this sentence. Now, it turns out that that sentence was not necessary to that prior case, nor was it raised in that prior case. Therefore, we're not going to follow it. Then they drop a footnote, and they say in the footnote, of course, it was perfectly appropriate and understandable that lower courts followed this statement in our prior opinion, right? So I think what that reflects is maybe the Supreme Court is not bound by legislative holdings itself as a matter of horizontal stare decisis, but post-Judges' Bill, there's at least a pretty pervasive attitude that the approach of lower courts ought to be a little different. So that was the first thing. The second point about, again, sort of Judges' Bill related, was that I kind of see agenda control, issue preservation and party presentation, and you sort of gestured towards this in the paper, as one instance of a broader set of problems around agenda control. I'm sort of borrowing from Henry Monahan here. It's one of many ways, which includes reformulating questions, cert, limited grants of cert, party presentation, that the Supreme Court can control, and other courts, exactly what issues come before it. And they have a fair amount of discretion to do that. And so, in light of all that discretion, I was quite struck by this sentence. It's on page 7 of your draft. When officials have a discretion, they have a constitutional obligation, very strong, to exercise that discretion in a manner that is consistent with both the letter, original meaning, and the spirit, original purpose of the Constitution. So am I to read that and to understand that in all of these agenda control areas, right, when the court is thinking about what cert petitions to grant or whether to reformulate questions, they have a constitutional obligation to exercise that in a way that's consistent with original public meaning? I mean, that would seem to suggest that the Supreme Court has a constitutional obligation to move towards the big bang, right, rather than the more slow introduction of some originalist principles. And I would just contrast that, I think, in an interesting way with Justice Barrett, a paper she wrote before being appointed as a judge, in which she said, I believe I'm quoting more or less verbatim, she said, institutional features of Supreme Court practice allow all the justices some of the time to let sleeping dogs lie. And as far as we are aware, she and her co-author, justices are not duty-bound to wake them up, right? And she said that in the context of justices are not duty-bound to awaken super precedents that might be inconsistent with original public meeting. But do you think that was wrong? In other words, are justices duty-bound to wake up sleeping dogs because of what you say about discretion in the piece?
Thank you, Thomas. So we definitely agree that the Supreme Court has sort of encouraged a legislative holdings model, and that lower court judges, even when they recognize that a statement in a Supreme Court decision is outside the legislative holding, so you have, sort of a statement that is obiter dictum under any theory of stare decisis, lower court judges tend to follow those decisions. And, for understandable reasons, they don't want to be reversed. But we just think that all of this is wrong, right? So we agree with you totally that that's what's going on. And obviously the Judges' Bill of 1925 is one of a series of changes in the way the Supreme Court conceives its role and the way lower courts conceive of the Supreme Court's role. The broader set of problems, absolutely, this is, something that we need to think very hard about. I do not think we were on a slippery slope, right? That is, I think that there can be modifications in the party presentation principle without modifications in everything else. And we certainly don't think that the Supreme Court is obligated to grant cert in each and every case in which current doctrine is inconsistent with the original public meaning of the constitutional text. I would like to say that my understanding of this is that we are in a transitional period. And where things go in the long run, of course, we don't know better than anyone else. This transitional period could end in 10 years from now. But from our perspective, we're in a transitional period. The transitional period is necessary because the Supreme Court has systematically deviated from the original public meaning of the constitutional text over a long period of time. And this may sound like special pleading to you, but I just want to say that's not originalism's fault. Originalism has to do the best it can to a systematic departure from fidelity to the Constitution, and a systematic from our perspective, a systematic undermining of the rule of law. And so does that create transition period problems? Yes. Would it be, I write these articles, Randy does too. One of the things I say in my articles frequently is originalism needs a fully fleshed out account of this transition problem, and then I write a promissory note in a footnote saying we haven't done it yet, that's something that has to be done in the future. I hope I can do it before I die, but if that's not possible, we hope someone else does it. But it is a real and serious problem.
Thank you, Adam, for your comment and the positive things you had to say. I think now is a good time to point out that there's an irony in the fact that you'll get more adversarial briefing if you do away with the party presentation principle to the extent we propose. That is, if it's well known that judges are going to be able to consider these arguments, then there should be a big incentive for the parties to get their say and provide adversarialness. So adversarialness is a good thing. We're not saying it's a bad thing. We just think gatekeeping by adversaries is a bad thing. In this area, in this limited area, when it comes to constitutional principle. And so we do think it's a happy result that you'll get more adversarialness if you don't let the lawyers control the arguments that can be made on behalf of a constitutional provision, which we think that's what's happening, at least it's what's happening below. And Richard, I hope you never stop coming to this conference, because you always provide, at least at some point during the day, you'll always provide just some, hugely provocative and interesting observation. And I include this one in that. Go bigger, it's dangerous to tell me to go bigger. It's something that I have a sort of a tendency to do on my own. I'm trying to rein it in. I don't think we're going to go any bigger than we are. I guess the one thing I would just say as to whether the courts are, the current judiciary is well designed to actually reach originalist results. I would say that, first of all, I think it can do so. Secondly, I think that it's not clear that it's any better designed to reach a non-originalist result. I mean, what makes the court well designed to pick any non-originalist theory you have, maybe with the possible exception of common law constitutionalism, where they're supposedly following stare decisis, except they don't follow stare decisis, so the system actually doesn't. Stare decisis is optional horizontally for them, and so that actually doesn't work. But with the exception of following some version of precedent, what pluralist theory is the system well designed to do? I think it's better designed to identify the original meaning of the text with the help of adversarial briefing, as well as amicus briefing, as well as scholarship, hopefully, that precedes a case in controversy arising, than it is in doing pluralist balancing. I don't mean interest balancing, but pluralist, multiple modalities in which it's going to pick 3 from column A and 2 from column B, and then forget everything that's in column C for the purposes of this case. I don't think it's well designed for that either. But I will also say that if you had a weaker version if the Supreme Court itself had a somewhat weaker version of stare decisis than it purports to follow even now, I think you should get incremental improvements in original understanding. I take Rob Leiter's paper today, that we're going to consider later today, as a good example of how it's taken 14 years for me to hear that argument. I wasn't hearing it out of the people that were arguing the collective rights view. I wasn't hearing it out of the people that were providing me with the militia-conditioned individual rights view. I was getting nonsense out of them. No offense to anyone here who holds those views, but this is an actually compelling argument that causes me to think harder about the limits of Heller, the way Heller was written in ways that I might previously have thought were really, really good, as opposed to the bad parts of Heller. It took 14 years. I think the Supreme Court should be open to adopt, if at the end of the day I'm persuaded by Rob, and I'm quite open to it, I think the Supreme Court should be open to, revising, modifying, tweaking the Heller rule to deal away with all the problems that this is now creating, this solely individual self-defense model is now creating in the lower courts. It's working terribly in lower courts. We're out of time. So anyway, I just think that if the court will reconsider what it's doing over time, it will reach better and better originalist results.
Thank you for those wonderful comments. We really appreciate
thank you.